Welcome to Legally Agile with Chris Werner.
Welcome to Legally Agile, the podcast for founders and executives of high-growth companies who want legal strategy that keeps up with their business. I'm Lisa Mosby, your host, and I'm here with attorney Chris Werner, founder of Vidar Law. Chris helps high-growth businesses navigate risk, seize opportunity, and stay legally agile without slowing momentum. In today's episode, we're talking about what happens when a key vendor or business partner stops performing under a contract and how growth stage companies should respond strategically before the situation escalates. Welcome to the show, Chris. Thanks for being with me today.
Hi, thanks, Lisa.
Yeah, when a vendor or a partner starts missing deadlines, under delivering or changing the terms midstream, what are the early signs that this is becoming a legal issue rather than just a business hiccup?
Yeah, I mean, there's no bright line rule for this thing. Obviously, you have a contract with your vendor and that has defined terms in it, but I've never seen sort of a business contract that there wasn't some slippage or some wiggle room on certain things here or there. I think the important things to consider are exactly how much slippage has been going on. If this is a vendor you've worked with in the past, so you kind of know their cadence. If it's a vendor that sometimes pushes things back a week or so, or if it's somebody who usually is delivering on time, it gives you an idea of is there a problem or not. I also think that most contracts have built-in wiggle room in them, right? So it's usually not delivery needs to be on a very specific date. Otherwise, it's a huge problem. If that's the case, and you think that there may be some slippage, that's something to get on right away. But I'd like to give you a bright line rule, but it's a little more of an art form. So I think it's a question of, is there a delay? Are they telling you that they can't perform or that something is going to have to be substituted? And how much is this going to affect your business and your sort of down the line agreements with other customers?
And you mentioned, is there a delay or a performance issue? What other kinds of things should leadership be reviewing internally before escalating this?
Yeah, so you don't want to instantly go to your lawyers necessarily because most of my clients and most businesses want to be efficient in how they're doing things. So I think it's leadership, whoever's leading the contract, whether it's your CEO or somebody who's the head of a department, they have to really think about, okay, what is it that's going on here, right? Is my vendor telling me that they're going to need an extra week to deliver? And can I live with that? Are they telling me that they're going to have to make a substitute in materials because of a supply chain issue or an unavailability of something? And again, the real question is, can we live with that? Is this something that we can deal with or not? And then you're also going to be looking for other signs, right? Are they saying that we need an extra week because they're a small vendor who is sort of overcommitted? Is there something bigger going on in the global economy? You got to look at those factors and see how likely do you think it is that this 1 week delay is going to slip into a longer delay, or that the substituted material is not going to be acceptable either to your business or to your customers. And so I think you want to look at those kind of things. And kind of make a judgment call on how big a deal this is.
Sure. And many contracts include limitation of liability, cure periods, termination rights, and dispute clauses. Which of those provisions tend to matter most once performance does break down?
Yeah. So all the things you mentioned are important. And if they weren't, they shouldn't be in the contract to start with. But I'll touch on just two things. So the first, limitations of liability. What those tend to say are that even if there's a breach, even if your vendor breaches the contract, you're only entitled to collect a certain amount of damages. A lot of times that's limited to the value of the contract or maybe some other set amount of money. That's very important and probably should be negotiated early on. If, for example, your vendor is supplying you with something that needs to be incorporated into a product that you've already sold to one of your clients downstream, that limitation of liability will tie into your contract with your customer. And so it's important to be aware of what those limitations are, because it will help you figure out, do I need to bring in legal help right away? Do I need to find another vendor right away? How big of an emergency is this? So, for example, if you have a limitation of liability that equals $10,000 with your vendor, but your customer, if you don't deliver, that's going to cost you $100,000. That's a real disconnect, and you need to be aware of that, and that will tell you how you respond to the potential breach of the contract. The other thing I think that is really important early on is the cure period. So a lot of contracts will say, if there's a breach, you have to notify the other side and provide them with an opportunity to cure the breach or make it better. Let's say, for example, that cure period is 2 weeks, okay? And you've built into your contract with your supplier 3 weeks of wiggle room in there, right? So you've said, okay, well, they've agreed to deliver on this day, but as long as I get it by this day 3 weeks in the future, there's still no problem. So they come to you and they say, hey, we have a small delay. We need an extra week. And you say, okay, fine. Extra week, no problem, still within the wiggle room. But this is all done very informally. Then they come to you and say, yeah, we need a couple more days. Okay, so now you're under 2 weeks until they're supposed to deliver, and they're still telling you there's a delay. What usually happens is that cure period requires a formal notice to the vendor. So now you have less than 2 weeks, but you still have to give them 2 weeks to cure. So if you feel like a vendor is potentially going to not perform or be delayed in their performance, you really want to know what that cure period is and what the mechanics of that are right away, so that you don't get in a situation where you've informally given them a couple of extra weeks and they still haven't performed, and now you're obligated to give them formal notice and another 2 weeks, which may be past your deadline.
And we talked briefly about calendars and how we all live by them. This is something that needs to be on the calendar, isn't it?
Yeah, absolutely. If you're keeping track of these things on your calendar, you should have very good visibility as to when these things are due and what those terms are. And so when you have these agreements first put in place, you should be calendaring those important dates.
Where do you see companies unintentionally weaken their own position, whether through informal emails, Slack messages? You said, out of the courtesy, you extended the agreement, but maybe it should have been documented at that time. Sometimes maybe side agreements or operational decisions made without checking the contract can get us into trouble. So you want to talk more about that?
Yeah. There's a number of ways that you can get yourself in trouble. And again, it's a little bit of an art form here. So there's the sort of harsh legal truths, and then there is the business realities. And so, especially with a vendor that you work with many times, you don't want to be too harsh right away. A lot of times it's better to give people an extra week or try to work something out with them. The problem comes when you're putting stuff into an email, giving more time, allowing things to be changed or substituted, and you're not checking with the other members of your internal team. So let me give you an example. I had a client who they had a vendor that was building out a specific marketing vehicle for them. When I say vehicle, I mean a literal vehicle, a van, that was very custom. So their vendor was building this out, and their production team the head of the production team was dealing with the vendor. The vendor started to slip on their delivery date and started to go further and further out on when this was going to happen. The production team said, okay, well, we're busy in-house. We can allow some delay on this, and it's not a big deal. What happened was they didn't check with the sales team, who was going to then resell this to one of the company's clients for a marketing campaign. So that time slipped, and they weren't going to be able to deliver. The sales team was really upset because their customer was upset that they couldn't deliver. And the production team had sent email and confirmed things allowing this time slippage. So by the time I got involved, it was very difficult to unravel this thing in a way that could make everyone happy. And unfortunately, the company was left going to its customers and trying to get a substitute. And it created a bad relationship with the company's customer. So these informal things, I know they happen, but depending on what they are, and especially if you're not talking to everyone involved on your own team, you can get yourself in big trouble.
And again, that calendar comes into play. And we are talking about growth stage companies. So sometimes systems aren't already automated, and they don't have all of those things that they need to keep track on things. For growth stage companies that rely heavily on a single vendor or a technical partner, how does concentration risk change the way you approach a potential breach?
Yeah, so I think there's two things. Number one, if it's a critical vendor and you've got your risk concentrated in that, I think you need to address some of the contractual issues early on and be aware of that. To the extent that you haven't done that or haven't done that sufficiently, um, you've got to be careful, because um, if it's a critical vendor, you need to make sure that they are still delivering. So you're going to want to look at how much sort of wiggle room you have and what you can do to get them to perform. Unfortunately, these aren't always contractual resolutions, right? The contract may say you have a right to cancel the contract. The problem is, you may need that thing that your vendor is supplying you, and you may not have a good way to substitute performance from a different vendor. And so, yes, you can cancel and not pay them, but that may not do you any good. So sometimes you do want to negotiate a different delivery date, an adjustment to the materials or what they're producing. Um, Oftentimes, that negotiation is critical. And as you are doing that, I would always recommend, if you're at that point, you get your counsel involved, because if you're going to develop a side agreement, if you are going to make an exception to certain parts of the contract, you want to make sure those things are documented and you're getting everybody on the same page that we can't let this slip anymore, or we can't make additional changes.
And when discussions shift from operational problem solving to lawyers getting involved, what typically changes in the tone and the leverage on both sides?
Yeah, some of it is lawyer specific, but when one side gets their lawyer involved, the other side is almost 100% also going to get their lawyers involved. When the lawyers get involved, things get much more formal. It's a little bit harder to sometimes have open discussions. If you've got a good lawyer who understands your business needs, they will find ways to keep those discussions moving forward. But the other side's lawyer may be hesitant. They may require more written documentation. Um, the lawyers are going to require more formality to what you're doing, and there's going to be commitments. You are going to probably be giving up some of your contractual rights if you're trying to renegotiate terms or get your vendor to deliver. So you have to be a little more careful, and anything that you say before and especially after lawyers get involved is going to be scrutinized. Every word is going to be scrutinized, and so you do have to be very careful with your communication then.
And Chris, if a founder realizes today that a key vendor relationship is unstable, what immediate steps help protect the company's position while still preserving optionality?
Yeah, so I think in most cases, I would say those relationships probably can be saved. And so if you have a relationship that you think is a little bit vulnerable, again, I would highly recommend that a founder talks to their counsel and discusses what the concerns are. So if the concerns are about performance, the timing of performance, the quality of performance, really start to dig in and see if that's something that can be fixed, right? Is there a little more time you can give them? Can you adjust some of the outputs that you're expecting? Those kind of things. If you think that it's vulnerable enough that you should start thinking of contingency plans, again, you want to start looking at what your options are. Number one, can you afford a backup plan? Number two, what's the timing of that backup plan if you need to go to it? Number three, what are your downstream agreements with your customers that may be affected by this? And is there a way to get out in front of that with your customers? Can you negotiate more time? Can you negotiate any change of terms with your customers before this becomes a problem, and potentially cut this off, even if the vendor relationship is vulnerable? The best practices is if you can identify a potential problem, deal with it with your customers before it actually is a problem. Often, you can resolve the issue without your customer ever knowing that there was a potential problem. And so those are the kind of things you should be looking at.
And Chris, I think we'll leave it there. Thank you so much for your insights today.
Thank you.
And to our audience, thank you for listening to Legally Agile with Chris Werner. If today's conversation sparked questions about your own company, whether it's legal foundations, disputes, or getting deal ready, you can find more resources at vidarlaw.com. You'll also find a simple 72-hour dispute response checklist you can share with your leadership team. If you found this helpful, please follow the show and share it with another founder or executive who'd benefit. And we'll see you at the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.